Good morning. It's my pleasure to take part in this webinar in conjunction with the Department of Internal Affairs. As Sarah has just mentioned, we've just completed a month-long roadshow throughout New Zealand, and it's awesome that you guys are able to be part of this through a webinar, for those of you that couldn't make the actual presentations. So my role with the webinar and with the joint presentations with the DIA is to put a bit of perspective around why lawyers and conveyancers have been included in the implementation of Phase 2. So with the work that the Financial Intelligence completes, we are able to provide some background to the typologies for money laundering and terrorist funding, and also through the submission of suspicious transaction reports, we can give some guidance around the type of typologies, the vulnerabilities that we see as being instrumental for Phase 2. As you'll see on this slide, we receive 3 different types of reports. So the first type are the suspicious activity reports, which currently come in as suspicious transaction reports. So as of 1st of July, there will be an ability for all people who are submitting reports to complete these online through Go AML as either a suspicious activity or, if there's a transaction involved, through a suspicious transaction report. As of the 1st of November last year, we had the introduction of prescribed transaction reports. So these fit into 2 scenarios. One of those is large cash transactions. That has a threshold of $10,000. So if a transaction involving $10,000 in cash occurs, then there is a legislative requirement to report it. Large cash transactions is exactly that. It is cash, literally the folding stuff. The other part of prescribed transaction reports are the international funds transfers, which are the wire transfers. So there are 2 requirements here. An international funds transfer involves the transferring of money either into New Zealand or out of New Zealand. So if the wire transfer crosses the New Zealand border, either in or out, and it reaches the threshold of $1,000 or exceeds that threshold, then once again there's a legislative requirement to report that. So obviously the 2 differences with these reports lie in the reason for suspicion. So your suspicious activity reports require you to make a decision on whether or not that activity or the transaction has an element of suspicion. The prescribed transaction reports are a legislative requirement that don't require any suspicion. The fact that it's happened means it needs to be reported. The third type of report that we receive are border cash reports. Now, when you travel internationally and you cross a border, you are given a departure card or an arrival card to fill in. One of the questions on those cards asks if you are holding more than $10,000 in cash. If you are, then you tick the box and you get a border cash report to complete. It's the role of customs to actually collect that information. They then forward it through to the Financial Intelligence Unit. Once we have that information, it gets collated into the Go AML database and it becomes part of our intelligence data. Now this slide shows you what happens when somebody tries to bring cash into the country in an unorthodox manner and doesn't declare it. So look, it's okay to bring money into the country, you're allowed to do that, but you must declare it. So on this occasion here, with the implementation of Phase 1 in July 2013, the dogs that you see wandering around the airport, sniffing your handbags and your suitcases, were previously trained to identify produce and or drugs. These dogs have since been cross-trained and are now able to identify cash. So not just bits and bobs that you've got in your wallets and your handbags, but significant amounts, wads of cash as we refer to. So in this case here, this passenger was identified as having not disclosed significant amounts of money hidden on his body. He was subsequently taken to a room where he was searched, and this is what the Customs found. So on this occasion here, $363,000 tried to be brought into New Zealand. So the outcome of this was the money was seized and subsequently forfeited to the Crown. So this gentleman decided he wanted his money back, so he appealed that decision, and some 2 years later, after the appeal process had been completed, the judge in charge of that decision agreed that the original one was correct. The reason being for that was that this passenger told the courts that he simply forgot that the money was there, and the judge at the end of the day did not accept that explanation. So when we have a look back at this slide, you can see that we do get some interesting things reported through to us, and all this forms a basis for our database. Now, the Financial Intelligence Unit is homed and housed by the New Zealand Police. So whilst we are an independent group within the police, we work on behalf of all government agencies. Once we've collected these reports, we go through an initial assessment process, and due to us being housed by the New Zealand Police, we have access to the National Intelligence application. So we can see by accessing that application whether somebody has criminal convictions, for example. We can see if they are wanted by any authorities. We can see if they have gang links. We can see who their associates are. So it's very important for us to have access to that information, and like most people, we have a risk-based matrix that we work from when we're committing our initial assessments. So we look at the person, we look at the transaction, and we look at the reason for suspicion. So if we have somebody that has previous convictions, they've also got other STRs that have been submitted with them as the subject, we have them with gang links, then obviously they're going to score highly on that part of the matrix, and more than likely that will go through for further analysis. Our analysts will have a look at the STRs that are sent through to them. They will have a look at open source information, and they will build a profile on that person or maybe the business, and as a result of what they find, an intelligence report may or may not be completed and disseminated out to one of our partner agencies. So you'll see on the slide there that we disseminate to the police, remembering that we are not a police unit per se. The police do form one of our clients, and we do disseminate quite a large amount of information to them. The supervisors I refer to on this slide are the 3 sector supervisors. So the Reserve Bank of New Zealand, the Financial Markets Authority, and of course the Department of Internal Affairs, who are your supervisors going forward. The other agencies we disseminate to include Customs, Immigration, Serious Fraud Office, Department of Social Development. So for example, if we are receiving suspicious transaction reports where a beneficiary is identified as depositing large amounts of cash into his or her account, then we would disseminate that to Inland Revenue and probably to the Department of Social Development as well. Because while beneficiaries can obtain some money through employment while they're on a benefit, some of the records that we are seeing deposited far exceed what would be expected. So those are some of the external agencies that we have disseminations to. Internationally, roughly around 150 FIUs globally, and we have the ability to disseminate information to them. I should mention here that whilst we have access to the police database, all police don't have access to ours. So any information that is held within the GoAML database is very strictly controlled. For anybody wanting information from us for financial intelligence, they must submit a request in writing to us, which is then assessed by one of our senior managers, and if the intelligence we hold would support or advance their investigation, then we would disseminate the intelligence from the report, not the report itself. So I think that's quite important for you people to know, that your information that you're submitting to us is protected, it's privileged, so you have a privilege between yourselves and your clients. We have the same privilege between the Financial Intelligence Unit and yourselves with the information that you're submitting. So it's important for you to know that that's secure. The Financial Intelligence Unit sits under the broad heading of the Financial Crime Group. So that comprises of us and also the Asset Recovery Units. So we've been through very quickly the process that we go through in the Financial Intelligence Unit once we receive this intelligence. Once the dissemination is made to one of our partner agencies, they complete the investigation. Our unit does not investigate. We simply bring all the pieces together into an intelligence report, which is then disseminated. If during the investigation stage one of those agencies establishes that somebody has acquired wealth or assets through criminal offending, then they will contact one of the asset recovery units in the area, and they will then take on the seizure and forfeiture of those assets. So we're going back to the good old saying where crime doesn't pay, and this is a very, very strong piece of legislation. It means that when the villains go to prison, they come out stripped of their assets, and they're starting from ground zero again. So it means that they are not gaining or benefiting from criminal activity. I think we can all agree that that's a very good thing. So from the inception of the suspicious transaction reporting in 2013, this slide gives you an idea of the number of suspicious transactions that we've received during certain timeframes. The large numbers that you see there to your left are the number of suspicious transactions that we have received, and the itty-bitty numbers on the right-hand side are the number of STRs that we have received from law firms. So some of you will be aware that there were obligations under the Financial Transaction Reporting Act 1996 to report suspicious transactions under certain circumstances, and I suspect that some of these are as a result of that. Now going forward, that's in the past. Going forward, we would like obviously to see those numbers increase. We believe that there is an incredible amount of intelligence out there that you folk can certainly contribute to, and I think as we go through these slides, you may pick up some areas that you were totally unaware of in the past. I think it's important to realise too that the legislation that is now involving you in the implementation of Phase 2 does not in any way indicate that there is a belief that you are money launderers, that you are representing money launderers. It is saying that through the work that we have seen already, through the typology reports, through the suspicious transaction reports, we can see that as Phase 1 has tightened up in the financial institutions and the financial industry, the villains are moving their money and their wealth into other areas. So they're looking at real estate, they're looking at buying flash cars, they're looking at buying flash boats, they're looking at using trust accounts, and we can see that from the operations that have been completed by the police and other agencies over the last 3 or 4 years. These are the indications where we can help you identify some of these areas of vulnerability that we see you may face. Knowing what those vulnerabilities are will help you with your risk assessments that the DIA will speak about a little later on, and it will also help you protect yourselves from being caught up in any of this activity. That is something that you certainly don't want to be doing. So what is suspicious in your world? This is a question we get asked regularly. It's not something that we can answer easily because whilst we have a very high view of most reporting entities, businesses, we don't know the nuts and bolts of it like you do. And more importantly, we don't know your customer. So you need to be really knowing what your customer does, who your customer is, and you should know where their wealth or their source of income is coming from. If you look at your customer and you look at the behaviours of your customer and you look at the services you provide, there are going to be certain indicators that may lead you to think that something is suspicious. And when you get to that stage, that's when you need to be looking at the submitting of a report. So there are a lot of different reference material documents that you can have access to through the Financial Intelligence Unit. There's extremely good guidance that the DIA have already put online on their website, which the gentleman will talk about a little later on. So we're here to help you get through this phase. Some of the vulnerabilities and the risk areas that are current also have been ongoing since 2013 and will continue. So cash is still king in the criminal world. Everywhere else pretty much is a cashless society. So when we have a look at people turning up with bagfuls of cash, either to buy a property or to pay a deposit for a motor vehicle or to pay for services, then that should be your first red flag. Cash is still king. It's surprising the number of people say, well, we don't deal with cash. No, we don't have cash anymore, so we don't need to bother about that. Look, if somebody comes into you and offers to pay you with a bag of cash, you will still need to report that to us as a suspicious activity. So just because you don't take it doesn't mean that you should not report it. That is valuable information for us. They may then turn around and go to somebody else, or they may give somebody else the money to bank into your account on their behalf, and then we lose oversight of who that money actually belonged to at the very beginning. So the importance of reporting is for the intelligence to show the source of the money, so who the beneficiary is and where the money is going to, so the destination of the money. The buying and selling of real estate is a huge area at the moment, has been for a while, where villains are putting a large chunk of their money in one transaction, in buying of a property. Globally, it's estimated around 30% of money laundering is done through real estate. So if this is a part of your business model, then there are certain things that you will need to have a look at, and there may be some changes you need to make to your business model to make sure that you have the protection, to make sure that you obtain the necessary identification, for example, of your clients. Dealing with high-risk jurisdictions is always going to be high risk. There are several high-risk jurisdictions globally that you need to be aware of. If you Google high-risk jurisdictions, you will see a list in what those countries are high risk for. Some of the more common ones, we look at obviously the tax havens, Seychelles, Belize, British Virgin Islands. For example, if you have people contacting you, wanting you to represent them from any of these jurisdictions, then obviously there are going to be certain requirements. It should raise a red flag. Why do they want to use you? Why do they want to use New Zealand? One of the key points here is that New Zealand is often targeted by the villains overseas because we're seen as a very safe place to do business. We're number one on the Transparency Index, which means that we're perceived, and I believe rightly so, to be a country of low or no bribery and corruption. So it means that if transactions are going through New Zealand and going off to a third jurisdiction, there is a likelihood that that transaction will not receive any kind of viewing by the receiving country. If it's going straight, for example, from Belize to Canada, then the Canadian authorities would be all over it in a heartbeat. But if it comes from New Zealand, then there's a high chance that it will receive no attention at all. So whilst we are very proud of the fact that we have this fantastic reputation globally, unfortunately it has attracted the bad element, and that is what we need to protect against. The whole regime is set up for the protection of the New Zealand border. So that is why we do deal a lot with customs and with immigration. We want to keep New Zealand a safe place to live in and a safe place to do business in. To complete some of these transactions or to make the money laundering side of things work for these villains, some of them will set up shell companies. There are several cases that we have seen coming through over the years, recent years, where shell companies have been set up in New Zealand along with client accounts, and then the money is transferred through. So once again, utilising the good name of New Zealand for the movement of money. Managing of client money. We had a very interesting one come through not long ago where some funds were deposited into a law firm's trust account for the purchase of a property. Now this property was also subsidised by a few other people, but the lawyers had no idea who those third parties were. So when you're managing your clients' monies, there's going to be a requirement for you to actually know who's dropping money into your accounts. This slide here gives you a very good analysis, or shows you that 21% of all the asset recovery unit cases that were profiled here involve the creation of trust and companies. Transfer of ownership of assets to a third party, 21%. So you can see here that through the intelligence that we already have, that this forms quite a high percentage. These are the areas of vulnerabilities that we would ask you to look out for, and if your business models contain these areas, these are the ones that you will need to have a very close look at in your risk assessments. In this example here, I'll just start off by indicating that the lawyer involved in this was a complicit lawyer. So he knew what was going on right from the start. Now look, don't be too perturbed about that. Every industry has a bad apple in the barrel. Everybody does. So I think it's important just to note that and here we're looking at the typologies and not the fact that we had a complicit lawyer. The person in the middle here is the lawyer. Person on the left is the offender. Now, in this situation, the offender has gone into the lawyer and discussed with him the purchasing of a property with a view to building a house on that property. There was a little bit of a problem in that the offender was a bankrupt and owed 1.2 million to the official assignee. Now, between the two of them, they hatched a cunning plan to open a trust account, and that the cash that the offender had access to would go through that trust account. A couple of weeks after the account was set up, the offender goes in with $300,000 in cash, gives it to the lawyer, who breaks it into 4 deposits into the trust account. That money was subsequently paid away for the purchase of the property. At this time, the lawyer submitted an STR, which was fantastic, except the lawyer put on the STR that the offender's girlfriend brought the cash in, not the offender. So that wasn't so good. A couple of months passed, and there was a further $129,000 cash taken into the lawyer. That was split into 2 deposits and subsequently deposited through the trust account. This was then paid away for the legitimate cost of progress payments on the building of the house. On the third occasion, the offender took in $122,000 in cash, once again split into 2 deposits through the trust account, and on this occasion the money was paid away to the offender's girlfriend. Now, the offender and his girlfriend had had a bit of a tiff. The relationship turned south, and this was the payout to the girlfriend to keep her quiet on all the information that she was privy to in respect of these dealings. So look, the important things here are clearly there was a large amount of cash involved, over $550,000. There was the split deposits going into the account, probably to avoid any suspicions, and going through the trust account. So the managing of those funds is another issue here. This slide here refers to the one I've mentioned previously, where there was a deposit for the purchase of a property into a law firm's account by the client. There were then several large cash deposits from other people into that account for that same property settlement. Now, the law firm had no visibility over those third parties, so anybody could have been putting money into their account for the purchase of that property. This is what I mean about managing the funds that are in the accounts, so that you need to know who's contributing to those accounts, and you should be able to identify those people. So you shouldn't just have random amounts of money appearing on your statements. You need to be able to identify how they've got there and who they've got come from. In this case here, as we've spoken about earlier, the banks and the financial institutions in phase one have really closed the door for offenders to use the traditional means for acquiring or having their wealth. In this case, the bank have followed their due diligence by going back to their account holder, which in this case was the law firm, and asked them some questions about who was it that deposited the cash into this account. And the law firm were a little bit embarrassed in that they could not actually give them that information. So once again, this just highlights the need for you to know what's going on in accounts that you are managing. This slide here looks a little more complicated, doesn't it? But look, it's not really. On the right-hand side of your screen, at the top you will see the criminal purchaser of a rural property, moving to the left of your screen in the big black box in the middle there. So the criminal purchaser knew the vendor, the complicit vendor of this property. So between them, they hatched a plan for the movement of the value of the property from the purchaser to the vendor. $50,000 in cash was given directly to the vendor, the balance of which was paid by the transfer of assets to offset that debt. So once again, we see here the involvement of a car, caravan, boat. This is what I mean by once that door closed from phase one, now they're looking at putting their wealth into assets and other means of storing the value of the money they're holding. They don't want to have a whole lot of cash, they want to have an asset. So when the complicit vendor in this case gave the cash that he had received to his lawyer, the lawyer sort of said, well look, we've got something worth A here, but we've only got B. Where's the deficit? Where's the balance? And the vendor says, look, don't worry about it, Sam. I've got what I need out of this. Can you just go through and complete the transaction? So the lawyer did that. Everything was completed. And on this occasion, the lawyer submitted a suspicious transaction report through to the FIU, and that became part of an investigation. So this was all based on methamphetamine dealing, so sadly most of our cases are linked to drugs, but it is good, I suppose, that it's being identified, it's being investigated, these assets are being seized, and the criminals are no longer benefiting from this type of crime. We've talked about the moving of funds through New Zealand. So New Zealand being a very attractive place for overseas offenders to try and move their money through because we have that great reputation. They're managing to do this through the structures that are available in New Zealand. So when we're talking about high-risk jurisdictions and structures, we're talking about people outside New Zealand, offshore clients who may want you to act for them by setting up trust accounts here in New Zealand, using you to complete these services, which will give a veneer or a level of legitimacy to what they're trying to do. One of the very popular ones, or ones that we see regularly, is usually for a purchase of a property where a amount of money is sent through to the account that's been set up by the New Zealand solicitor, and then under instruction they will indicate that they've changed their mind, they don't want to buy property in New Zealand anymore, they're going to buy it somewhere else, in Australia maybe, and they will ask for that money to be remitted to a third jurisdiction. So I know a lot of law firms that we've spoken to before today have indicated that they will only return money back to the person that they have received it from, which is a very wise, prudent move. If you are transferring it off to a third party, you really don't know what the movement of that money is representing. So it could be that they're transferring value for a debt that they owe for some other reason, or it may be legitimate, but you don't know that. What it should do, though, is raise a red flag if somebody wants you to remit money off to a third-party jurisdiction. Trust in companies, as I mentioned earlier, is a very popular way for criminals to move money around and to hide where their money and their assets are. In this particular case, we have a person in the middle here, of the left of your screen. Oh, I'm sorry. Pushed the wrong button. Here we go. Person 1, this person embezzled $3 billion from a company in the United States. Now, through the use of New Zealand Trust and Companies, which was set up by a New Zealand law firm who actually specialised in setting up these structures for offshore clients, this person that had completed the embezzlement was able to buy a lot of high-value assets as a result of this structure. Now you'll see it looks very complex, and that's another indicator as well. So the villain wants to remove themselves from the actual transaction. They want to make it as hard as possible for anybody investigating anything to find them on the first look. They will layer their interests. They will use these trusts. They'll use a number of them. They'll use a number of companies, shell companies as well, where it's going to be difficult to unpeel right back to the core on who is the actual beneficiary. So this person managed to use up just about the whole amount of this money to buy these assets. Interesting here that the law firm involved didn't know that they were being used in this way, and this is one of the reasons why the Department of Internal Affairs, in conjunction with the FIU, have done this roadshow to help you become aware of what some of these vulnerabilities are. Virtual offices and shell companies pretty much run hand in hand. The virtual office is usually unattended. There'll be a phone that is forwarded on to somebody else, somewhere else. And once again, it is really to hide who the beneficiary is of a company. There are law firms and other firms in New Zealand where the company is the registered address for an offshore company. Now, once again, that is purely to use the good reputation that New Zealand holds for their website. It looks really good for them to say that they have offices in New Zealand. There'll be a panoramic view of the viaduct or Wellington Harbour. So that's very attractive to people, and it gives people a sense of comfort if they know that there's a New Zealand component in anything that they're doing. The roles of the people involved in the anti-money laundering and the financing of terrorism is quite important. So a lot of the questions that we've been asked throughout the roadshows are, you know, well, the banks see it all, so why can't they just report it? Why do we have to do it? So there are different understandings and different relationships between different people. So what you know as a lawyer of your client will be different to what a bank knows about that same person. it'll be different to what a real estate agent knows about somebody buying a property. So where the whole regime sits is that with the submission of the suspicious activity reports through to the FIU, with all the different levels of relationships and information you hold, we then put all those pieces together like you would a jigsaw, and we can then work out who New Zealand needs to be working on to make us and keep ourselves a nice safe place. So the information that we receive, or the intelligence that we receive, is for that purpose. The police will file the reports, or do the police investigations and prosecutions. We just help them with the intelligence at the very beginning. So you'll see from this slide that each sector actually has its own role in how we work together. And it needs to be working together too. No one area is going to be able to keep this under control. We must all work together. Some of these helpful hints here, you'll hear time and time and time and time again that you need to know your clients really well. So even if you have had clients for 20 years, you really need to know them very well. People's relationships change over periods of time. You need to be aware of that. You need to be constantly updating and reviewing your relationships with them, the services that you provide for your clients. And if at any stage during those reviews there's a need to change them, then that's what you need to do. The gentleman following this presentation will be going over some of that with you, and you'll find it very helpful. This reporting overview just shows you the reports that we are currently receiving. So suspicious activity reports, you'll see there, they split into the two. There's a suspicious activity report with a transaction, or there's one that is just the activity. So the activity is, as I said earlier, if somebody rocks into your office asking you to represent them and drops 20,000 cash on your table as an incentive for you to take them on, if you decide not to go through with that, then obviously you could still do a suspicious activity report, and that would be very valuable. Now, whether you retain or whether you take on a client, that's your business decision to make. And I know that you do have some code of ethics and whatnot that you might need to factor into your decision making. But once again, that's a business decision. We do get asked from time to time, Carol, this is the circumstances we've got. Do you think we should take them on as a client? Look, I can't tell you that. That's a business decision for you to make. And a lot of guidance is available to you from your industry governance as well. So the Law Society, I know, have some very good documents to assist you along these lines. So your decision to report. So once you have ascertained that you are captured under the Act and that you have a situation where you think, yes, this requires a report, you need to register to use GoAML. GoAML is the only portal you can use to submit reports through to the FIU. Now this slide here gives you the link for registering as a new entity. So each law firm that is captured and required to report needs to register their law firm as an entity in the first place, and then decide who's going to be submitting your reports and have them register as a user. So once that has been submitted through to us, we will then invite you to some hands-on training on how to submit those reports. We do that nationally, and what we may do is once we get a number of people in one locality, we may go out to you and ask if somebody within that locale can actually host the event. So we don't need anything flash. We need perhaps a boardroom with a table that would seat maybe 20 people, access to a Wi-Fi, and everybody brings along their own laptop or device, and then they can log into the test site and we can complete the training from there. So we've found that that's very helpful for new people to do that. It's a good way to learn and a good way to hear a few more war stories. So on here I've got the main web page here for the Financial Intelligence Unit. You'll see the prescribed transaction reporting on the right hand side. Some firms will not need to report either. Some may need to report both large cash transactions and international funds transfers. If you've got a large number of IFTs, then I would point you towards this page here. There are 3 ways that prescribed transactions can be reported to us. One is manually, one is through an XML upload that is automated to a certain extent but does require human intervention, and then thirdly, the business-to-business or platform. Have a look at this website here, have a look at the number of reports you think you're going to need to file, and that should step you through which one is most appropriate for you. Once you've logged in and once you have become a user or have access to Go AML, there's a resource library that you have access to, which also gives you a whole lot of good information for reporting, what the quarterly typology reports cover, and different aspects of the business, what you may find as vulnerabilities in your line of work. On the left-hand side of that page, you will see some links to other information and other websites where you will find some very valuable information. Look, that brings me to the end of my presentation. Once again, I'd like to thank you very much for the opportunity to present to you, and I'm now going to hand over to Mike Stone of the DIA.
Good morning, everyone. So as Carol said, my name's Mike Stone. I'm the manager of the AML team for the Department of Internal Affairs, and it's my pleasure to have the opportunity to talk to you all today about some obligations under Phase 2 of the AML Act. Thank you for giving up your valuable time, and we'll get straight into the content. So, just so that you're aware, we pitched this content for the roadshows at people that we believed already had some existing knowledge of the Act, maybe had done some investigating into what their obligations would already be, and hopefully have read our guidance. If that's not you, that's fine. Some of this stuff might be a bit new to you, and hopefully, if you bear with us, some of your questions will be answered through the content. So we'll obviously be giving you a bit of a quick overview about what the Act is, touch very quickly on laundering and financing of terrorism. Most importantly, what does this mean or potentially mean for you and your business, and what you can expect from us and what we would like from you in return. Now, while these learning objectives are up on the screen, I'd just like to talk about some of our key messages. So, we genuinely believe that this change in the legislation will disrupt people's opportunity to launder money and help safeguard our very important reputation, which Carol has already talked about. We want to remain one of the least corrupt nations in the world. We think this is a sizable issue, about a $1.35 billion issue in fact, and this will go a long way to increase public trust and confidence in business in New Zealand. We do actually genuinely believe that this will enhance your professional reputation. And we've had lots of contact with your colleagues over the last month around the country, and some really good feedback, in fact, that this regime is not as onerous and cumbersome as people might have first expected, and that in fact it won't require you to do a lot more than you're already doing in the good course of everyday business. The emphasis that we're providing around reading our guidance, I'm sure, will come across very strongly during the course of this morning's session. Please, we do direct you towards the Lawyers and Conveyance guidance that's on our website. We've consulted extensively on that. We've really thought hard and long about how we can improve the readability of that guidance, make it less prescriptive, include lots of real-world examples that will help you in practice. And I strongly recommend that piece of guidance for you to look at. That guidance sits along some other key documents that are really going to be useful for you. So my colleague Jamie will talk more about the actual obligations. But you need to think of, on one hand, your risk assessment, and on the other hand, your compliance program. When you're considering the development of your risk assessment, one of the first things that you need to look to is the National Risk Assessment produced by the Financial Integrity Unit. That sits alongside the sector-specific risk assessment that has been produced by the department that is available on our website. Those are the two documents that you need to read first when you are considering how you are going to understand, formulate risk for your business. On the other hand, when you're looking at your compliance program, go to the DIA guidance and also have a look at the risk assessments and compliance program prompts and notes that is on our website. There's a lot of really good guidance available, but I imagine if you were to go out and start open source searching and go to all the various supervisors' websites, that you might be a little overwhelmed. So if I could just direct you towards those key pieces of information first. This is a risk-based regime. You'll hear us talking about risk a lot. We assess risk nationally. We require you to assess risk in your business, and we also work according to risk. So we prioritise our supervisory work based on risks that we identify. And we need to acknowledge that this is new to New Zealand. We are learning a lot from you and you from us, and there will be ongoing learning that takes place and improvement in the way we supervise you and the way you interact with us in the future. It's a living process. These are living documents. We require them to be embedded and be a living part of your business. We don't want to see these things implemented early for compliance sake and then locked in a cupboard to gather dust. They have a real world implication on you and your business and on New Zealand's reputation, and we want to see that maintained. We consider ourselves and often refer to ourselves as a responsive regulator, and we're really proud of that approach. I'll talk about that a little bit more later on and what that means for you in terms of the way in which we interact with you and the way we'd like to engage in this work. The obligations that this Act places on you need to be proportional. One of the advantages of having DIA as your supervisor, and clearly I'm biased, is that we have extensive experience dealing with a range of different financial sectors, 14 of those, across a whole range of size and complexity. And we're very good at tailoring our approach to the specific needs of your business. It's worth acknowledging that the obligations will affect you differently. If you are part of a large firm, it's likely that you can disperse those responsibilities more broadly across a number of people. If you're a sole trader, sole practitioner, it's likely that the front-end obligations will all be upon you, and that will require some more work on your part. However, we require that you think about this in a proportionate way. So we don't want to see a small business or an individual producing a large, comprehensive and excessively detailed compliance program and risk assessment that does not apply to their particular business. We are used to seeing very good risk assessments and programs that are only very small and very short, but very tailored to that particular business. So that's what we want to see. Technology has made sure that we're not immune from practices that are occurring all over the world, and as Carol has already said, Phase 1 has most definitely pushed those engaging in criminal activity to look for more elaborate ways to conceal the profits of their criminal activities. Technology is allowing and favouring anonymity and allowing criminals to hide behind multiple layers of complexity. We at the DIA are not a law enforcement agency, and I think that's a really important thing that you need to understand. So we're a regulator, we're your supervisor. If an individual was to engage in money laundering, the individual themselves would be investigated by the police. If that individual was to use a business that was supervised by the department, then absolutely we would look at the compliance obligations and the level of compliance of that business and whether that business was complicit in allowing that criminal activity to take place. But fundamentally, the reason why I make that distinction is because we come from an educative approach. We actually are here to help you meet your obligations. and education is normally always our default position unless we have information that requires otherwise. And lastly, from the roadshows, something that came up quite regularly and is worth addressing is the issue of templates. Absolutely, the department realises that templates exist and have value. The real skill with templates, like any of the templates that you or I use as part of our daily work, is how you tailor those specifically, edit them, change them, utilise them in your daily work. So the reason why, an absolute reason why we don't endorse templates per se, is that we have seen over the last 4 years with Phase 1 entities, people producing template risk assessments and programs that aren't nuanced to their business, aren't tailored to their particular needs, and that's not something that we want to see with Phase 2. We appreciate that you have the technical expertise and the skill to know that, that templates have value, but you need to tailor them and use them appropriately. So quick money laundering 101, well, it's the process to clean criminal money and make it look legitimate. We know that it's funded through property and expensive goods and services. It normally takes place in 3 stages: placement, layering and integration. We won't go into that other than to say that the evidence shows that the legal profession could be utilised in any one of those 3 stages. Terrorism financing is a little different. There have been cases that have been identified in New Zealand of people attempting to fund terrorist causes overseas, and with the global nature of society nowadays and our global reputation, it would be naive to think that we would not be victim to terrorist financing in the future. How big is it in New Zealand? Well, it's a big problem. We've talked about this being a $1.35 billion problem, predominantly from fraud and illegal drugs, being the profits of those being laundered in New Zealand every year. Really though, when we look at the social cost and impact, we know that that must be much higher than that dollar value. Carol's talked about tax evasion and internationals and local criminals trying to launder funds through New Zealand businesses because of our reputation, and we know, as I've already said, that New Zealand has been exposed to threats of funding of terrorism in the past. While that slide's up there, I'll just talk about the impact of Phase 2 on the DIA and what that means for our business and the effect on you. So we're a current team of 17 people split between Wellington and Auckland. We anticipate growing to approximately 50 to 60 people by the end of the year in direct response to the need created by Phase 2. We're likely opening an office in Christchurch in the South Island to better tailor our services to our South Island communities. We do really value providing individualised and tailored advice and guidance to each and every one of you when we can. We operate in this shared supervisory model that Carol has talked about. So New Zealand decided not to opt for a single supervisor such as Austrac in New Zealand, and it decided not to opt for a multi-supervisory approach like our colleagues in the UK. And we went somewhere down the middle. So the Reserve Bank of New Zealand supervised banks in New Zealand, the FMA, financial advisors and other financial products providers, and the DIA is the government's catch-all. And I'll talk about who exactly we supervise soon. But why did the government pick the DIA? Because we are really experienced at dealing with a diverse range of reporting entities in a diverse range of sectors and tailoring our approach proportionately to that. And as Carol already said, we work quite closely with our government colleagues, both nationally and internationally. This is our world on a page, and if you concentrate on the 3 boxes at the top there, you'll see they're coloured differently, red, orange and green, and that is according to risk. So currently the department supervises, as I said, 14 different sectors. Some of those include the remittance industry, trust and company service provision and casinos. You see those on the top left. They are our high risk customers. Now, because you are in that sector doesn't mean that it means that the activities that you are engaging are classified as high risk. So naturally we are concerned that the obligations are in place in those high-risk areas, and we tend to focus some of our work in that area to ensure we have mitigated that risk. As you move further along, you'll see tax pooling, currency exchanges in the moderate, and further down into the whole bunch of niche financial services that are a lower risk. Phase 2 will bring in the box in blue. So yourselves, accountants, conveyancers, real estate agents, high-value dealers and the New Zealand Racing Board in a phased-in approach. And as we know, lawyers and conveyancers were the first cab off the rank, coming in July of this year. Well, yes, we know that Phase 2 extends the legislation to cover your businesses and others. It also does make some changes to Phase 1 businesses. We haven't included those in this presentation for obvious reasons. So you may or may not realise that it was always actually the intention of AML CFT legislation that lawyers would be included. But it's fair to say that issues such as the Panama Papers have brought the increased focus on the role of corporate and trust structures and money laundering to the fore and accelerated that policy process. Carol has talked about this in that this is not about treating the legal profession as pseudo-detectives or assuming that there are dodgy activity going on in the legal profession. Actually, quite the opposite. It's about utilising the specialist and trusted knowledge that you have as a trusted legal professional. You will identify red flags that won't be picked up by banks and other financial institutions when you interact with those very same customers, and the information that you have will form a very important part of that jigsaw puzzle. And I can't emphasise enough that as we move towards the Financial Action Task Force Mutual Evaluation of New Zealand in 2020, that this shift in legislation will bring us into line with international best practice. And we are being looked upon by our neighbours around the world as to how effectively we bring lawyers and others into the AML regime. Now, this is a diagram produced by the Financial Action Task Force, and I won't dwell on it for too long other than to say it shows two trajectories of involvement, and we want you to be on the top line. So at the start there, you'll see that it talks about innocent involvement with no real identification of red flags or some basic mitigation taking place. Where we actually want you to be is up in the alert and proactive boxes. So we want you to understand your customers, the risks in your business, and report effectively when you identify that those red flags have been triggered. We don't want you to fall down into the willfully blind, corrupt and complicit boxes at the bottom there. That's our worst case scenario. We regularly acknowledge at the roadshows that we do not want you and your business to be on the front page of the paper, because it's very likely that me and my colleagues will be alongside you in that headline, and that's the worst case scenario for me as it is for you. We definitely want to be working with you in that alert and proactive box. But we acknowledge that it's going to be a bit of a bumpy road for some of you, and that you won't always get it right. That is just part of what we do, and we will work with you to help you where we can. Right, down to the nitty-gritty. Now, I won't dwell on this stuff for too long because the list is extensive. So what activities are covered? So you need to go to look at Section 5 of the Act. You're all experts in reading legislation. Go have a look at Section 5 of the Act that gives you the definition of DNFBP, and establish if you are engaging in or conducting any of the activities covered. This is an activities-based regime. The mere fact that you are a lawyer will not necessarily mean that you are covered. If your business and the services you provide to your clients doesn't fall under one of these captured activities, you will not have any obligations under the Act. One of the things that came up generally is what is the ordinary course of business. So I will say that your judgment as a trusted legal professional is what we are relying on in terms of establishing ordinary course of business. Think about the factors about, is it normal, is it unremarkable, is it frequent, regular, does it involve significant amounts of money for your business, a source of income, or significant resources? essentially the common sense approach to what ordinary course of business would mean. Now, the department will be sending out communication, a letter to you to help you self-identify whether you are engaging in any of the activities covered by the Act, and having communication with you to identify whether you are captured. So watch out for that communication that is coming. But in the meantime, you can be looking at these activities in the legislation and making that determination for yourself. Just a few things to note. So the Act applies to the law firm, not separately to the partners and other individuals within. Thinking about in-house lawyers, well, you need to look at the activities they are carrying out. But generally, it's highly likely they won't be captured. Something that's come up in questioning is litigation covered. No, generally litigation is out. However, there is a fishhook there that says that if you are managing a means of payment, for example, the payment of court fees to a third party, then that particular activity would be captured. As I said, there's fish hooks, there are a number of them, so rather than try to go through every single one of those, I'll steer you back to the Section 5 of the Act and to the guidance, and encourage you to read that through thoroughly and before you make a determination as to whether you think the activities you undertake are captured. Just one thing to note, that if you are undertaking a captured activity in a personal capacity as opposed to your professional capacity, and one we can think of is that you might be a trustee for a registered charitable trust in your local community. In your personal capacity, that activity is not captured. Right, so now I'll shift focus. Jamie is going to talk a lot more about the individual compliance obligations and just talk more generally about our approach to supervising you and regulating. We are a risk-based responsive regulator, so that summarises our approach to you, and this slide speaks for itself. We do want to genuinely understand your business and the challenges that you face in it. Nobody knows your business and your customers better than you do, and we are relying upon you as trusted legal professionals to help tell us about your businesses and the challenges you face. We want to help you protect your business from being misused by criminals. We don't want you on the front page of the newspaper or on the news in the evening that your business has been utilised by criminals to launder money. We are accessible, we're proportionate, we're consistent, and we are fair. And we use a range of regulatory tools. So when I say that we are educative in our approach, we are generally by default, but that doesn't mean we're afraid to take action where the need arises. And if you want to see what that action looks like in practice, then I encourage you to look at the Ping An decision, particularly around the objective test around suspicion. We will work together as a group as we grow into these roles, there's no doubt about that, and we will support you where we can. One thing that we hear through our learning through phase one is you need us to be proportional and fair. You want to operate in a level playing field. If you're an engaged business with engaged staff, spending money on AML CFT compliance, you want to know that you're going to get credit for that, and that in fact me and my team are going to be looking at those who are not engaged with us or don't want to engage in their obligations. And that's entirely fair, and that's our attitude too. I don't want to deploy our resources across the country to the people who are doing the right thing. I want to deploy those resources where the need is the greatest. We will prioritise our activity to decide where we can have the most impact, and we won't do that at a random ad hoc way. We'll do that just as we require you to do it. We will inform ourselves by risk. That will also mean that we will engage with those of you who are doing everything right when perhaps we might be in one of the regions engaging in some other work as well. Ultimately, we are here to help. How do we do what we do? Well, we do it in a number of ways. We do compliance checks. We have an operational team of people that are here to check that you are engaged in the obligations. And we do that in a couple of ways: desk-based reviews and on-site inspections. So a desk-based review is a technical check of compliance. we will contact you, give you plenty of time and notice to get your risk assessment and compliance program sent through to us, and one of our team will do a technical check on those documents to make sure they're compliant with the Act. If they're not, there's some shortcomings, we'll give you some proper, meaningful feedback on how to improve those. And I think it's fair to acknowledge that our approach to that process has changed and matured over the years. When the regime first came into effect, the approach was to request those documents from you. When you asked for how those could be formulated, we didn't give you much help with that. And then when we found shortcomings, we asked you to fix them, but we didn't generally tell you how to fix them. That's all changed. So now we will tell you where we think those shortcomings are, and we'll give you some real meaningful and practical advice on what you can do to improve upon those. Second stage compliance check, if you like, is the on-site inspection, and that's a check of practical implementation. So we don't want, like I said before, for these documents to be sat in a cupboard gathering dust. We want them to have real meaning and real use in your business, and an on-site inspection is a method for us to check implementation and effectiveness. So several of my team might come and arrange to see you, sit down with you and talk about your obligations in practice and look for evidence about how they're being utilised by you and your team. Guidance, advice and information. So there's lots of guidance, lots of really good advice and information on our website, the website of our supervisory colleagues, the FIU and others. I encourage you to go there. I encourage you to have a look at that information. There's a sector risk assessment that talks specifically about the risks being faced in the legal and conveyancing sector. You will have an annual report obligation. Now, Jamie will talk a little bit about this more. What I will say about this is please don't be too put off by this. It's not onerous. We try to make this as easy for you as we can, and to give you some idea of how easy it is, we receive about 98% of those annual reports on time every year without issue. So we would expect to see exactly the same. And there's been a lot of work going into tailoring the questions of those annual report to the legal sector to make sure that is not too onerous to you. What I would encourage you to do is, when you get a chance, is start having a look at the information that you collect and whether you might need to put any steps or things in place to collect that information for annual report time. We do a lot of work with other agencies. We're very collaborative in our approach with the other agencies here in New Zealand and other jurisdictions around the world. And I've talked about the range of tools from education, remediation, which is a more formalised expectation from us that you will improve upon the areas that we require you to improve on, through to published and non-published warnings, enforceable undertakings and court action. As I can't emphasise again enough how our approach to that is about being proportional, responsive and fair. So that's my part. Hopefully that gives you a flavour of how the DIA will interact and engage with you over the next coming months and into well into past July the 1st. And I'll hand over to Jamie Lynch, who is a senior member of my operational team, to talk about exactly what you need to do to prepare for Phase 2. Thank you.
Thanks, Mike. Okay, so I'm going to be covering off the nitty-gritty and what you should be doing to be getting ready for Phase 2 implementation. First things first is, Mike's emphasised this already today, but is read guidance. Not just lawyer-specific stuff, but there is interesting guidance around identity verification, there is codes of practice, there is quarterly typology reports. All this information is out there and available, and you should start looking at it now. And from that, you'll find out your compliance requirements. It's really important to remember, and it's been alluded to before, your compliance obligations are going to be commensurate with the level and size of risk that your business faces. And from that, you'll be able to start thinking about appointing a compliance officer, which I'll touch on more later. Identifying your money laundering and terrorism financing risks by conducting a risk assessment, preparing your AML CFT program, and ensuring you know your customers to the appropriate level. So first off the rank is appointing a compliance officer. The Act specifies that this is someone who's suitably qualified and trained, with a direct reporting line to senior management, and more importantly, the ability to influence them if things need to be changed. It's really good from our perspective to have someone who isn't shy to engage proactively with us, and it's someone who's going to be committed to the position and be able to do it for a long term going forward. It's not necessarily a full-time position, and it's not something you should look to appoint as a full-time role. In terms of work, it's going to be 1 or 2 hours a week, so similar to a health and safety professional in your team. The next step is reading the sector risk assessment. You know your business better than we will. You know the history of your business, and you know the products and services that you offer. You know who you deal with, and you know the types of customers that you have. So your risk assessment should be based on your practical hands-on experience of that business. And you might also tailor it to the specific risks that you see. Sorry, I'm on the wrong slide here. Sorry, apologies. Sector risk assessment. This is the published sector risk assessment guidance, which applies to all Phase 2 entities. It assesses the inherent risk, that is, the risk that is applied before the AML CFT controls are applied. The easy access to and wide geographic spread of legal services, coupled with the lawyer's gatekeeper role, and the potential usefulness in many examples of money laundering and terrorism financing, means that your sector presents a medium to high inherent risk of money laundering or terrorism financing. This does not mean that the risk of money laundering or terrorism financing occurring with your own business is medium or high. You need to look at the extent to which your business is exposed to the specific vulnerabilities identified in the legal sector in order to assess the risk for your business. And developing your own risk assessment, which is where we started from. So as I mentioned, you know your business better than we ever will, and you know the history of your business. So your risk assessment should be tailored to those factors. What we want to see in that risk assessment is your hands-on practical experience of how your business operates on a day-to-day way. So think about the factors that are identified in the Act and the complexities of your business. Is it large or complex? Do you offer high-risk services? Do you deliver services face-to-face or remotely? What kind of customers do you deal with regularly? Are they individuals, companies or trusts? Are they large or small? Are they offshore or onshore? And you think about what sort of countries you regularly do business with as well. So when you're doing this, as I mentioned, you should be using the sector risk assessment, and you can compare the risks identified in there and narrow it down to how it affects your business as well. You should also refer to the prompts and notes document, which the DIA have already published. It's really handy to provide pointers and guidance on to how to develop the risk assessment and what sort of things you should be looking out for. The risk assessment is a living process. In your risk assessment, you need to state how you intend to keep it current and how you intend to react to emerging risks and trends in your sector. Carol's Financial Intelligence Unit produce quarterly guidance and information which will help you develop that. So parallel to your risk assessment is your AML CFT program. And this is going to be your nuts and bolts. It's going to be your 101 guide as to how you conduct your AML CFT program and information on how to do that. It must be based on the risks identified in your risk assessment, and it should include procedures of ongoing requirements, including CDD, and how to identify and report suspicious activity reports. Again, it should be tailored to your own specific business. So what we'd like to see as a regulator is something that new staff members could pick up, read and understand right away, and they would have a good understanding of what their AML CFT obligations are. What I would recommend from a regulator's perspective is start thinking about it early. The sooner you get this developed, the better. We recognise it's going to be a challenge, but don't leave it to the last minute, it'll just make it harder. Again, as with the risk assessment, it must be regularly reviewed, and it should be identified any deficiencies that are missing from there. When we come and do on-sites and we do desk-based reviews, we'll be looking to see how you're regularly interacting with your program and risk assessment and how you're keeping it regular. So as part of your program, there are ongoing requirements. Again, the prompts and notes document will be really useful in terms of identifying what those ongoing requirements are and how you might best meet them. The primary and most important one, I think, is the customer due diligence. We'll touch on a little bit that more later on. But you need to verify the identity of customers before providing any services covered by the Act. Prescribed transaction reports, Carol's already touched on, but you need to think about how you're going to monitor them and how you're going to report them to the FIU. Go AML training will be really useful in that, and that will be really useful in determining how you're going to do it. Monitoring customers' accounts. In a legal context, that means monitoring the activities and transactions in your client file and comparing that against what you know and can reasonably expect from your client's behaviour and business activities. It doesn't mean monitoring the financial transactions of your client's bank account. The banks will do that for you. It includes requirements about vetting staff, record keeping, regularly reviewing your AML CFT program, the regular audit, which is done by an independent auditor every 2 years, and the annual report, which you submit to us every year. So customer due diligence. There are 3 levels of CDD. You'll need to be sure that you're using the right level, which will depend on the unique factors of each of the business relationships which you form, the characteristics of the customers, the nature of activities and transactions you're facilitating, and the potential for money laundering or terrorism financing risk. The 3 levels are standard CDD, which is common for most situations for most New Zealand transactions based with New Zealanders. Simplified CDD, which is used for specific customers or customer types which are considered low MLTF risk. These customers are specified in the Act and usually are government-backed organisations or government entities. And then there's enhanced CDD, where there are factors creating a higher money laundering or terrorism financing risk, which is specified out in the Act. If you're doing enhanced CDD, you have to think about the source of wealth and funds and verifying this information to a higher level. You must use your own risk assessment and AML CFT program to determine which kind of CDD you're going to be doing on each individual customer. And there's great advice provided in the Identity Verification Code of Practice, which provides a safe harbour specifications detailing exactly what you need to do in terms of knowing your customer to the appropriate level. So doing that practically, identity verification can only be done by collecting and citing documents, data or information provided from a reliable and independent source. You are required as part of your program to keep records of this information. And again, the amended Identity Verification Code of Practice provides best practice for anyone conducting name, date of birth identity verification on customers who are natural persons that have been assessed to be low or medium risk. So standard CDD will be your bread and butter and what you'll be doing most of the time. And when it applies, you'll need to be finding out the full name, date of birth, the relationship to the customer, if it's not the customer you're dealing with, the address or registered office, the company identifier or registration number. And you must also obtain information about the nature and purpose of the proposed business relationship with the customer. What we got as part of our roadshows was questions around when CDD should be done and needs to be done. Ideally, it would be done before a business transaction or relationship begins, or at the beginning of that relationship. But there are fast-paced scenarios that are common for some lawyers or conveyancers, which would delay the ability for you to verify the customer's information. In these instances, which should be truly exceptional, there are exception handling procedures specified out in the Act, and what we're looking for you to do in that instance is record a fact-based justifiable reason as to why you've delayed CDD, so we can look at it when we come and do our on-sites and desk-based reviews. So, legal privilege. The Act does not require any person, lawyer or otherwise, to disclose any information that the person believes on reasonable grounds is a privileged communication. The AML CFT Act requires all reporting entities to report suspicious activities by filing SARs, which Carol touched on earlier. If it's not possible for you to file an SAR without disclosing a privileged communication, you must not do so. It's accepted that in some cases that's going to be the case. For your records, the information, a privileged communication is defined in Section 42 of the AML CFT Act. Ultimately, it would be for you to determine whether a prima facie case exists on the facts before you. It may involve whether there's credible evidence that a communication is made for a dishonest purpose or to enable the commission of a crime. You must keep records of any assessment that you make. It's not a defence if a reporting entity did not actually consider a transaction to be suspicious when objectively it should have been, but it is a defence if a reporting entity believes on reasonable grounds that the documents or information relating to the activity were privileged communications. Where we've landed as a regulator also is trust accounts would not be held to be privileged and financial transaction records are not going to be privileged. So in order to submit an SAR, you should be able to have some financial information which you can submit. Mike touched on annual reports earlier on. It's submitted every year to us electronically, and it covers the year the 1st of July to the 30th of June. You will start doing it in 2019. The information we're going to be asking for our annual report is information we'd be expecting you to be reasonably keeping as part of your AML CFT program. It shouldn't create extra work for you, and you should be able to schedule it to reflect your financial reporting. So you can incorporate that into the same process. The information is really useful for us because it helps us to get to know your business better. It helps us to identify what you're doing and how you're doing it, and it helps us to target our resources more effectively. It also helps us to identify any gaps of knowledge that exist within the sector and how to target our guidance going forward. It helps us to develop our own risk assessments, and it helps to be a more effective regulator going forward. So it's a really useful tool for us, and as Mike said, it's really easy to submit. It's 98 to 99% of people manage to do it in phase 1. There's also going to be guidance provided later on in the year with regards to annual reporting, so it should be out at the end of the year, I believe. As part of the AML CFT program, you'll be required to get an independent audit every 2 years. It doesn't have to be by a chartered accountant or financial auditor. It's not a financial audit. A suitable person is defined in the Act, and it could be a business assurance auditor or an AML specialist, or someone who works in your field who is sufficiently removed from your business, for example, another lawyer. There's not a requirement that you pay for it. We don't have an expectation that it's a paid audit either, so you might find yourself in a quid pro quo environment where someone does yours and you do theirs for them. You must be able to provide it on request to us, and again, it's used as a targeting tool by us. It helps us to understand your business, it helps us to target who we're going to approach and who we're not going to approach, and it helps us develop a useful compliance program for people. So just to cover off what we spoke about today, what we expect of you generally. We need to own and understand your AML CFT program. Ownership isn't the sole responsibility of the compliance officer. It's a responsibility of senior management, and it needs to percolate throughout the business. To demonstrate ownership, the program needs to be actually put into practice by those that own it, rather than locked away in a filing cabinet. By understanding, this is demonstrated by tailoring the program to the unique needs of your business and making sure that everyone who needs to be adequately trained is so. This is what we look for when we review your program. The importance of owning and understanding your program is one reason why we urge caution with the use of standard templates. They do have a place and they are useful, but we need you to tailor those templates to reflect the realities of how you operate on a day-to-day basis. Finally, we are here to help. We're a responsive regulator, as Mike alluded to earlier. We want to help you get it right. So if you're struggling with this, then engage with us early and we'll do what we can to help you get through it. And these are the key messages and stuff we'd like to take away. I can't emphasize enough how important it is to read the guidance closely. There's a wealth of information out there which will help you develop your programs and risk assessments, and they'll be really useful for you in the coming months. So think about appointing your compliance officer early, get them Go AML trained, get them registered and get them educated. Make sure they're ready to go on July 1st. Think early about putting in place planning around your ongoing requirements, such as the annual report, the audit and the review process. and look at how you're collecting CDD information. It might well be that you're doing sufficient already, and if you're not, think about how you can raise that to the level that's required. So these are our contact details going forward. I understand we have some questions from the floor, which we'll be happy to take now. Okay. Are we all squeezed in sufficiently?
Squeezing, Carol.
Okay. So,
I'll take the first one. So a question was asked, probably best answered by me, which is, can you please provide the reference to the decision you mentioned on the objective test for suspicion in Ping An? So yes, succinctly, that is not a subjective test. Suspicion is an objective test that any reasonable person would make based on the same available facts to that person. So just to clarify that suspicion is an objective test based on a reasonable person on the facts available to them. Jamie, would you like the next one?
Okay, this is a theoretical question. A client who recently migrated to New Zealand and transferred money in his or his company's bank account, and from a New Zealand bank account transfers money in lawyer trust accounts to settle a purchase. Is there an obligation on a lawyer completing settlement to ascertain from where the money came in the client's NZ bank account? So to cover that off, basically there's a need to perform CDD and EDD when necessary, and that's going to be based on your risk assessment and your AML CFT program. You need to think about where the client is based, the AML procedures that exist in that country, and whether you can rely on the information you're getting. The obligation is always going to rest on you to ascertain that risk. So when you're doing that, and you're doing, as a regulator, the expectation would be you'd be doing EDD on customers that are outside New Zealand. So you've got source of wealth and source of funds to look at, and that's going to be carried out as part of your EDD assessment. And you also need to ascertain the nature and purpose of that business relationship. So it all flows back to doing your risk assessment early, doing good EDD, and that being reflected in your program.
Right, back to me. So next one from me is, can you expect reminders to be sent out to all law firms for annual reports to be filed? Yes, absolutely. So we have a system of sending you out early reminders via email to your designated compliance officer that will prepare you for the lead-in time to annual reports so that you have plenty of time to file. There's also a 2-month window where the portal is open for you to file your annual reports. At the moment they are a simple PDF upload. I'll acknowledge that's a bit cumbersome, but as part of our expansion we are looking at developing a new system that will allow you to have that complete that obligation much quicker. And in fact, when that obligation rolls out to you in 2019, we will hope to have that system in place already. It is, however, always a good idea to have some internal controls and reminders in your systems to alert you to when that's required. Hand this one over to Jamie.
Okay, the question is, have DAA estimated the cost to law firms throughout New Zealand of this compliance regime? I imagine if several hundred law firms are all preparing their own risk assessments and hiring additional staff to comply, then the cost will be substantial. Initial workout on costs was carried out by MOJ a couple of years ago. Phase 2 tries to reduce compliance costs. We provide DBG opportunities and reliance functions, which are all set out in the Act. You can share certain obligations of the Act through these processes. I don't consider there's a need to hire new staff. I think if you read the Act and you read the obligations set out in a compliance officer, you'll realise it's a job for an existing staff member. It can be part of an existing work portfolio that they do. As I alluded to earlier, the AML CFT regime is a proportionate regime. So if your business is a small business, and their compliance costs will be significantly lower. If you're a large business, they'll be higher, but a lot of stuff will be covered off by existing functions in that office. Again, what I'd recommend you do is go and read the guidance and find ways which you can minimise those costs. We appreciate there is going to be some work up front, there is going to be some initial costs, but I think as the regime matures, you're going to find it's reasonably cheap to go forward, and in terms of work and both money.
Right, so the next one will be for Carol. It's when we fill out a prescribed transaction report as required, do we need to disclose this obligation to our clients? Now, I think there's a couple of issues that Carol will touch on, is that's the difference between PTRs and SARs, or suspicious activity reports, and then Carol's also going to talk about the tipping off provision.
Right, so as Mike said, this shouldn't be confused between the difference here between the legislative requirement for prescribed transactions to be reported versus the level of suspicion that we're asking you to make a decision on for suspicious activity reports. So I think when this has come up previously with our roadshows, we've spoken to some of the law firms present, and what they have suggested that they might do is to include what their obligations are from a legislative requirement when they onboard a new client. So maybe including it in the rules of engagement when your client signs off to take you on as their lawyer. So then they are made aware through a document that there are requirements for you to provide some legislative reporting. Now, whether you're happy or comfortable with that, I think that's probably an industry decision to make. You're obligated to report the PTRs, but there's no obligation for you to actually advise your client that you've made that report. So it may be sufficient to cover it off in your terms of engagement or rules of engagement. It sounds a bit wary, doesn't it? But maybe let's go terms of engagement. So with the tipping off, I think the easiest way that we've described it in the past is if you think of tipping off as telling, you can't tell your clients that you are filing an STR because you think there's something dodgy going on with what they're doing. So this does not mean that you have to cease your relationship with your client or stop any transaction that's going through. That once again will become a decision made by yourselves based on a number of factors. So if you remember, tipping off is telling. So the legislation requires you to have a certain amount of information about your client, so you do have to ask questions. Asking questions is fine. It's the telling that equals the tipping off. So I hope that clarifies that for you.
And that probably leads into this next question, which is if we are suspicious about the transactions, are we obliged to complete them? And I think Carol has summarised that quite nicely in saying that there's no obligation for you to stop that activity, but you may decide that the suspicion or the raising of red flags warrants a report, which is entirely what the purpose of the regime is about. It will be up to you as a trusted professional whether you decide to continue that business relationship, end it, or not engage in that particular service for that client. But again, we trust in you to make that professional judgment.
Okay, we've got quite a few questions around am I captured, essentially. So what I would say to all those questions is the legislation is activity-based. You need to read that carefully and identify if you're doing those activities. That's how you're going to know you're captured. As Mike mentioned, we're going to be writing you to allow you to self-identify. If you don't carry out any of the activities set out in the legislation, you are not captured. As soon as you do any captured activities, you will be captured by the Act, and we need to be reporting to DIA. A lot of it will be quite straightforward. We have a question from a barrister who just does barrister activities. Based on what she said, no, you would not be covered. What else do we have? Petition without a trust account. If you're just taking fees, if it's not included as part of PTR, it wouldn't be included as part of the PTR because you're not covered if that's the case. And in-house lawyers, again, it's activities based. Our thinking is in-house lawyers probably wouldn't be covered based on our understanding of what you do, but again, it's something you have to read the legislation by yourself.
And just to build on that, if you are making that assessment yourself and you are struggling at any point to determine whether it's a captured activity, please engage with us, give us a call, send us an email, and one of the team will provide you with some practical advice. And like Jamie said, we will be making contact with you, we'll be reaching out to you to ask you to help us to make that determination, but we realise that that might not always be easy, so please engage with us early, we're more than happy to help. the best and surest way that you can get meaningful advice is to use the AML CFT at dia.govt.nz email. It'll come through to the team, and we can get onto that advice for you quickly. Carol, you've got one there.
Yes, I have a question here. Do all law firms have to register on FIU? Is it mandatory for law firms to register on FIU/Go AML? So following on from Jamie's previous comment, if your firm carries out any activity as defined in the Act, then yes, you're in. So a reporting entity has obligations to report SARs and PTRs, so you would then need to register your law firm as an entity, which on the slide you are seeing is under the Go AML registration piece under FIU. And then once you have decided who's going to be submitting your reports, have them enter as a new person registration. If you're registering for the first time as a new entity, the new entity and new person can be completed on the same form. So once that comes through to us, we then begin the training process of inviting you to a session. So the only way reporting can be completed is through Go AML. So your first decision is, are you captured? If you're captured, then yes, you do need to register as a new entity, register your person, and then the training process will begin. And as Mike said just now, if you've got any questions you're not sure about the reporting side of it, the registration side of it, please come through the Go AML at police.govt.New Zealand inbox.
Question is, does my risk assessment need to be sent to the DIA as our supervisor? And if so, when? No, come 1 July, please don't flood us all with all your beautifully crafted risk assessments, because we would drown. Allow us to make contact with you. So we will get in touch with you by way of letter, formally requesting you to send your risk assessment and compliance program and associated documents through to us for a technical-based audit. We may, however, decide further down the track as our involvement with you matures that we might send a request for your independent audit also. So we have generally said that we can be as helpful as possible with how we will advise you on drafting those documents. With all reasonableness, we have a limited resource too. So if you have particular questions, things that you need to get advice upon, please come to us, but don't send those risk assessments to us until we require them from you.
Okay, we've got one here about vetting staff and what we expect as a regulator. Look, it's going to be subjective again, depending on the size of your business. If you've got a comprehensive vetting process when you hire staff as part of your hiring policy, that could be well be sufficient for the AML CFT Act. Ultimately, it's up to you to make a decision. You need to consider the risk, what the person's going to be doing, and you consider how comfortable you are and how well you know them and how well you want to know them. There is some great guidance material in the lawyer's guidance around suggestions about what you might want to consider doing, but as I was saying, in most cases the vetting for new staff is probably going to be sufficient.
Right, a question here on the thresholds for, or are there any thresholds for submitting suspicious activity reports? No, there isn't. Suspicious activity reports, whether they be transactional or not, there requires no threshold. So any amount could be suspicious. In fact, a couple of our more heinous offences have smaller dollar values. For example, online child exploitation is one of the more heinous offences that we deal with. And now that has transactional values ranging from $20 to $200. So that would generally be payments going to the Philippines, which is the high-risk jurisdiction for online child exploitation. So, you know, that is an amount that is likely to fly under anybody's radar. So I know from Phase 1 entities, they have those set up as transaction monitoring rules to identify those transactions going to the Philippines that may involve this type of activity. So the other one that is of a low dollar value typically is terrorist funding. So what we have seen there is account set up where it is under the guise of a charitable organisation with low dollar value donations, as they are called, go into the accounts. The money accumulates, and then prior to a terrorist event, the account is closed down, the money is withdrawn, and then that money is used for that terrorist event. So you can see two very good examples there of where we can't have a threshold, we don't want a threshold. Anything suspicious like that should be reported. Now that is totally opposite, of course, to the prescribed transaction reporting, which, remember, is a legislative requirement. They do have thresholds. So the legislative requirement thresholds exist for $1,000 for international funds transfers, $10,000 or more for large cash deposits. Any report that has a suspicion component has no threshold. I hope that's cleared that one up for you.
Okay, we've got one here from a sole practitioner asking, who do you appoint as a compliance officer if they're a sole practitioner? Ideally, sole practitioners, you'd be your own compliance officers. The Act says it must be an employee, but there is a potential to outsource it, but there has to be a very good reason for doing so. Ultimately, it's a job which would be best done by the compliance by the sole practitioner themselves. There will be conditions applied to it if you try to outsource it, and I'm not quite sure what they'd be. We'd have to discuss that, maybe by email or by telephone call. As I say, the compliance officer role is something that's going to take maybe 2-3 hours a week at most, and usually just half an hour a week. So ideally, it would be yourself.
Okay, so the question is, are cryptocurrency transactions captured? So that opens a can of worms. That one, does it ever? I will say that that the supervisor, so currently the state in New Zealand is that cryptocurrency platforms and trading is not captured for AML CFT purposes. However, their capture currently is being looked at by the supervisors and Ministry of Justice potentially to occur in the very near future. So continue to watch that space. In regard to your particular activities and businesses, I would say that if you are engaging with clients who wish to make payment or transact in virtual, digital, or cryptocurrencies, that you need to consider the risk associated to those transactions. We know that certain currencies and platforms and exchanges foster and provide for anonymity, which is hugely high risk, and you would have to consider why your customer or client was wishing to engage in that particular service or payment method, given that it is not a mainstream accepted method of payment. On the general cryptocurrency regulation debate, I would simply just say watch this space.
Right, a question here. If a client takes a loan from a New Zealand bank to settle purchase of a property but deposits balance of more than $10,000 in cash direct into our trust account, it is not possible to know whether deposit was cash, as bank statement does not mention that. What will our obligation in such an instance be? So clearly there you're not going to know if your customer or by what method your customer is depositing that balance. The onus there would be on the bank to make any reporting requirements on that, unless you knew that the activity was suspicious. The activity itself was suspicious. So one of the examples that we sometimes use is if a client opens an account with you, or you're managing a client's account, and they've told you that they're regularly going to be every month, say, putting in $2,000, and then all of a sudden on month 4 that becomes $5,000, month 6 it's $10,000, and you're seeing a steady increase in the amount of money going into that account, that may indicate the requirement for a suspicious activity report. It may mean that you just ask your client whether these circumstances have changed, that you have noticed that there's been an increase in the amount of their deposits per month, and that's a little bit out of kilter maybe with what your initial discussions led you to believe. So once again, it's just looking at a number of different factors and making that decision yourself on whether or not you think that's suspicious.
One from me. So, do you need to let us know who your AML CFT compliance officer is, and do you need to register with the department? Well, we don't have a formal registration function in New Zealand, but yes, we would very much appreciate if you could let us know who your AML CFT compliance officer is if you have already appointed that person. You can do that via the email inbox of either of those emails provided to you, or you can wait till we contact you proactively and go through that assessment and advise us. We will be asking you for that information at that time. We will obviously be keeping a record of all the lawyers around the country who we believe are captured under the Act.
So we've got one here about verifying the source of funds coming to trust accounts. And I know I've talked about this before, but again, it depends on the level of risk, and that's what it's ultimately going to come down to. You need to be taking a risk-based approach in terms of verifying the source of funds. You need to think about the customer, who they are, where they are, what they're based on, the jurisdiction they're living in. You need to think about the nature of the transaction which you're planning on conducting based on those funds. You need to mix them all together and think about how far do I want to go to have that level of comfort that I know where the money's come from and what it's going to be used for. And that, again, is going to be a subjective decision that you're going to have to make as a business, and it's one you have to record and be able to tell us when we ask you about it. So really the onus is on you to make that decision and let us know how you drive that up.
Thank you very much. I think that brings us to the end of the webinar, so thank you again for giving up your valuable time. We really appreciate the opportunity to connect with you all and deliver this content. And on behalf of Jamie, Carol and I, we encourage you to make contact with us if you have any particular questions. Thanks very much.
Well, thank you, Carolyn, Jamie and Mike for your very instructive presentations and for answering all of those questions.